Oh, it's you again, Miss DiFiore. Okay, have at it.
So good morning again, and I'm back with the same issue, slightly different situation. But in the
Again.
meantime, the fourth district has issued an opinion, and we filed a notice of supplemental authority. So this is a case in which the homeowner had a water leak. There was a limited water damage endorsement issue, which in 2020 went in Mr. Nation's favor. It has since not necessarily gone that way for him. But in any event, there was a $57,000 or $90,000 RCV claim settled for $30,000. $5,000 went to Miss Dawson, and the other amount went to her attorney. There is no
Is
relief.
that case different from ours? Because in that case, the allocation, I suppose, of the payment was made expressly for attorney's fees and costs.
I don't know that that makes it distinguishable from this case because in this
Well,
case, Miss Dawson filed an affidavit expressly stating that the
okay.
allocation was for
All right.
attorney.
So it's your position because her affidavit said, had a contingency fee contract under which I was supposed to pay X amount, got reduced, but that's what that was for, right? So your position is if there is a contingency fee contract and there's a recovery, FIGA doesn't have to pay the settlement because there's a contingent attorney's fee agreement.
So again, I think we covered this at the last one. If
Yeah, it's been covered over and over again.
uh,
But that is
yeah.
that your position? I mean,
No, we both feel that FIGA needs to should pay a portion that's allocated for attorney's fees because that shows that it's not covered under the policy at that point. And here they
they come back and say,
documented
yeah,
that
I
it
think you
wasn't.
misspoke. You say FIGA is not supposed to pay the amount that's allocated for attorneys.
Right, right. And in other words, we
So,
pay the
so if there's no
5,000.
allocation, if it just says we're going to settle this case for whatever it was in this case, $30,000, and there's no mention whatsoever of where you send it.
I think at that point, FIGA is faced with a settlement that does not specifically identify an uncovered claim, and they'd be obligated to pay it. Huh?
But the basis for your claim assertion that there's an uncovered claim here is because
This
the
is
insurance.
Dawson said, we're paying attorney's fees with these monies. So yeah. And if
And
you
so
look at
you're
what
saying if, and so is FICA ever going to ask that question? Well, Miss Dawson, what are you going to do with this money?
so remember this comes to FIGA with
I mean,
pretty
because
much the things are already set up. So
would you agree that if not all, virtually all, or a great many cases, there is a contingency fee, attorney's fee agreement?
well, those contingency fee agreements say we'll take a percentage or we will take whatever the court awards as an attorney's fee under
If
60.
there's an attorney's fee award, but there was not one here, and FICA would not have to cover an attorney's fee award. I think we can all agree with
We
that.
can all agree with that. So
So the question is does FICA get off the hook for the claimant's individual uh, contract obligation that is wholly apart from the insurance company, wholly apart from the claim? FICA gets off the hook for that.
I don't know that I understand that question. What do you
Okay,
mean?
so you have a contract between the claimant and the attorney, and it does not bear at all on the recovery from the insurance company. So you're saying that FICA can still not have to pay that whatever that percentage charge is going to be.
If it's not dependent at all on a recovery,
It's dependent on a recovery, but it has nothing to do with the insurance company. The insurance company is not part of that deal. The insurance company is not paying that attorney's fee. The insurance company is paying the claim.
well, and I think again, we come down to when it's been identified as an attorney's fee, then it becomes and then they're clearly showing that this was not part of the covered claim.
Okay, now where in this record is it identified as an attorney's fee?
In the affidavit that Miss Dawson filed in support of the
Okay,
motion
but
to
you've
enforce.
objected to that affidavit, at least here,
I
right?
have.
Because you say it's parole.
Exactly. We
So you're
do.
relying on that parole evidence to make your case.
Well, if so in other words, if we ignore Miss Dawson's affidavit, Then
Okay.
we have an allocation that said
Because you know what? At the time
5% of
FICA
this.
refused to pay, it didn't have her affidavit, correct?
No, what we had was an agreement that asked us to allocate 75% of the settlement to the attorney,
It's
which,
to send the check to the attorney. It didn't say for what.
well, it didn't say for what. It just said 75% of the settlement, which would be a violation of any sort of
Not
fair
sending it to the
allocation.
attorney. What if it said send the whole thing to the attorney? Quite
For the
often that
benefit of
happens
the
too.
insured, I think, again, if it
It
said
didn't
send
say
30,000
one way
to
or
the
the other.
attorney. I'm sorry, what?
It wouldn't say necessarily say one way or the other. Just send the check to the attorney.
For the benefit of the insured, I don't think FIGA could say we wouldn't have evidence that there's an
And,
uncovered
and what
claim
if
at
it
that
doesn't
point.
say for the benefit of the insured? I think that would probably be implied by law.
Well, I don't know that it would be, because if they write a check to the
Certainly the
attorney, it
attorney
could be
has that
vanished.
obligation, correct? I mean, I mean, what my concern here is what FIGA is doing is if there's any hint that some of this money might go to an attorney, it's gonna claim that it doesn't have to pay the settlement agreement.
So what FIGA is doing is saying that the legislature has specifically said that the funds in the insolvent estate cannot be spent on attorney's fees.
That's not what the legislature has said.
They did. They said they
No, they
can't
said
use,
covered claim, correct?
right, but and a covered claim is not include
Okay,
anything
so a
that's not
covered
within coverage of the policy.
right. So you have something. So you have a claim, and it's settled for well less than the claimed amount, the damages.
Right.
And it says send the check to the attorney.
Send the check to the attorney
FICA's
without
gonna
any
not pay
indication,
that settlement.
with no indication that any money's going to the insured. I do think FIGA would have an objection to that. I think the
How does
legislature would have an
FICA know
objection
it's
to that
not
as
going to
well.
go to the? I mean, FICA, I have a real concern here that what FICA is doing in the trial court here touched on it. Is it saying, claimant, you don't have the right to pay this to your attorney if you want us to pay you. That's bottom line, is what you're saying. Did FICA pay the $5,000 to Ms. Dawson?
I don't remember seeing that in the thing, but
Yeah,
I'm
I
sure
don't think
FIGA
so. So
offered.
what was FICA's basis for not paying that?
Well, Mr. The name of the attorney below escapes me, but he argued there was no settlement at all because he said there was no meeting of the minds. But at this point, FIGA does not want to argue that there is no settlement. The argument is that only $5,000 of that settlement is owed, and I
But
think the
FICA
reason
didn't
we
know
haven't
that
paid.
FICA hasn't paid that either.
To my knowledge, we have not, because it's been up on appeal. So.
What difference does that make?
I think we're just waiting for the court to give us guidance so that we don't have to issue a
Whether
bunch of
do you need to
seconds.
write that check plus another check, or you just want to do it all in one?
Right, right.
But okay.
Well, in fact, I do think that's what the judge told us to do, was to issue one check for 30,000. And
It
so in
told
order
you
to
to issue
comply
the
with the court's
checks
order, we
according
could
to
only
the.
do that. So yeah, so.
Yeah. I know I'm using up your time, but we've been through this before.
We've been through this before, and we filed a bunch of requests for oral argument, and I know
Yeah.
we've come up in front of you and some of the others before, and the issue is that FIGA needs guidance. So what is it about the fourth district case in which the allocation of attorney's fees is expressly stated as it is here that would then say that it's not a covered claim?
Well, that's
And
what I'm trying to get at. What
right.
is there a difference between here and
I
Judge
don't
Lipton's
understand what
opinion?
difference it would be. I don't,
Other than
that was not
other
my
than in
case.
other yeah. Oh, you're not on that case? I didn't notice.
No, Miss Klein handled that. She and
Okay.
I communicate, and when she circulated this around, she indicated that it's, you know, there's an express statement. Well, in this case, the Dawson case, unlike the last case we had, there is an express affidavit that says this is for attorney's fees. So I think that this case falls in line with the fourth district's as compared to the last one. And I get that you're skeptical of that.
It seems like your position is that regardless of the affidavit, there is this email that says 5,000 here, $25,000 there. It doesn't say for attorney's fees. So is it FIGA's position that anytime it thinks someone may have a contingency fee arrangement for an attorney, or in this situation where there's a letter saying 5,000 to the client, $25,000 in the lawyer's name, does that mean FIGA has the ability to conduct discovery to find out, is there a contingency fee? Because if so, then FIGA's position is we're paying a portion of attorney's fees and we can't do that. I mean, is that taking it to its extreme? What I think is a reasonable analysis is FIGA's position. We're always entitled to know, how is the lawyer getting paid?
Well, and I think in a case like this, and again in the case in the fourth district, there's a suggestion that this is not a contingency fee because of the allocation. If you told me it was 30,000 and then we only sent 25 or 30% to the attorney, then that might not be a reason for FIGA to question, and that might be the guidance that FIGA needs. But
Well, does it make a difference? Does it make a difference that the attorney's fee in a contingency case is based on is as a result of a separate contract between the attorney and the client that does not involve the insurance company, and it's measured by percentage of recovery, either at trial or settlement. But if there's a recovery, it's going to be a covered claim. I mean, you're not suggesting that the fact that there's a separate agreement between the client and the attorney to be paid a percentage of the recovery disqualifies that payment for FIGA's.
That's right. I'm not suggesting that.
Okay. So what about this case suggests it's anything other than that?
The allocation of 75%, since that would be an unlawful fee contract, as far as I understand.
No, because that we know that 75% wasn't just for fees. It was fees and costs, and the fees were reduced, based on this.
Well, we found that out, and according to the affidavit
that you rely on an objective.
That was for interest, Mr. Nation.
So when you found that out, did FIGA pay the claim?
No, they did not. They were arguing at that point that there was no settlement, which we lost, and then we had an order that said we had to issue one check, and we appealed it.
Okay, so your concern here then is you've been told to issue one check?
Well, that's part of the concern, and we believe that
because I'm not clear on I'm not clear what it is you're complaining about at this point, Ms.
Well, at this point,
do you acknowledge that either under FIGA's theory that this affidavit that you rely on and object to, I've been there, describes a contingent contract between the attorney and client, and it does not involve an award of fees that the insurer was required to pay?
Okay, it does not involve an express order requiring an insurance company to pay, but that's not like it's a vacuum. Anytime an insurance company agrees to pay an amount to the insured, they're going to owe fees, and that contingency fee agreement included the right for the attorney to recover what they consider a statutory fee. So
yeah, but the attorney but you also know that the attorney then did not seek to recover a statutory fee.
According to their affidavit that only came out because FIGA said,
but once the affidavit came out, what's your problem?
Again, now I outlined $25,000 for things that are not covered under the policy.
Again, that's the fee that's owed by the client to the attorney. It's not a fee that's owed by the insurance company.
Well, it is if we're paying it.
Ms. Fiore.
So again, I think what we are asking the court to do is to provide some guidance to FIGA that indicates when FIGA has a legitimate reason to dispute whether or not they're being asked to pay a statutory fee. And there I've
helped you use 15 minutes. I don't recall whether you reserved.
I don't think I did, because I think you and I have been around.
Yeah, we've been around. So let me ask you this, though, just to clarify. I think we have 3 of these cases in our court at this point.
I think I have another one scheduled in January.
Coming up. And somebody submitted a list of these cases that are in the DCAs around the state. There's probably a dozen altogether, maybe.
Oh, there's probably more, but yeah.
Yeah. I mean, some that I haven't made the list yet. All right.
Exactly. Or we didn't know about them. So.
Yeah. All right. Sorry. I'll give you a few minutes for rebuttal when you come back.
If I need it.
Yeah. Okay. Mr. Nation. We're getting to know each other pretty well, Mr.
I know.
Mr. Nation, you're up.
Yes, sir. Mark Nation on behalf of Ms. Dawson. I feel like I'm intruding on a family discussion here.
Oh, I know, but take notes.
I am. I will point out the 4th DCA case, Watchfire, doesn't have the word global settlement, doesn't have the word contingency fee in it. It has 627428 in it throughout. And so I think that's distinguishable. And as I was listening to the discussion, it dawned on me, assume this, it's a $30,000 settlement. And after this settlement's reached, DFS comes in or the government comes in with a tax lien or something and said, hey, part of that money's ours. You need to
Right.
put up.
And then you're gonna have to like engage in some sort of fact determination about whether some portion of that total was attributable to something that DFS has a lien on, kind of like you do in hospital cases.
Yeah.
Right. So that was one of the questions I was going to bring up, because everybody, FIGA anyway, feels like it needs some written instruction. So might these cases be handled in that way? When you have a lien case like that you're describing, or a hospital lien, you'll have an evidentiary hearing, correct, to determine whether some part of that number was lienable.
Yeah, in my scenario, nobody knew about DFS or the hospital. The hospital will be an auto case, so you know about it.
Right. But you'll know you get a global settlement, just an unallocated number, and the hospital wants some of its money back, and the judge has to decide how much of that goes to the hospital.
Right. They'll do an equitable distribution hearing.
Correct.
The example, though, that's if they know about it beforehand. I'm saying somebody comes in after
the fact
and says, hey, we need our name on the check. Then FIGA is going to say, well, we paid $30,000 as a global settlement. We didn't even know about you. Now you want to be on the check. How much do you want? Because we don't have to pay that. That's just an example of it. But back to our scenario, I don't know that I need to talk much about it. It is clearly a contingent fee agreement. And because this is being recorded, it sounds like the plaintiff's attorney is getting the bulk of it. About $18,000 of that was cost.
Right.
And then the rest was a reduced fee. Client was happy with that, and it got done. FIGA has no business getting into Miss Dawson's business of paying her attorneys at all. And so I don't see how FIGA can be successful in these circumstances and under this scenario when there's a contingent fee agreement with the plaintiff's attorney who's going to be paid, and they're agreeing to pay their lawyer separately. I don't know that I have anything. Y'all been through this. The Hernandez case, if you would look, it was PCA'd, and I put an appendix in. It's a cut and paste brief. Same issue that we have here today. That was recently PCA'd, and FIGA did file a notice of related case on that. So unless there are any questions, I don't feel like I can contribute much more on that.
Thank you, Mr. Nation. You don't get points off for not using all your time.
I got you. Thank you.
Okay, Ms. DiFiore, you got anything to rebut?
I do think that this case involves an evidentiary hearing that was not noticed as an evidentiary hearing, which we've talked a little bit about. And Mr. Nation just brought up a scenario where, in fact, there would be. I'd also like to point out that the $17,000 that allegedly went for cost, $8,000 of that went to Mr. Nation's law firm. So in addition to the whatever fee they took, there was an additional $8,000 going to interest or whatever that is. So
well, I think that also what happens is firms come out of pocket on costs too, and they're entitled.
And I won't disagree with that. Yeah. But I think we've been round and round. I think we understand. I do object to considering PCA opinions as authorities, but it is what it is. So
well, but we can look at our own records and see how we have. So all right. I have a feeling we'll see you again on this. So thank you so much.
Cancel that one in January. Yes.
All right. In order to leave our courtroom, you need to click the leave button